Hi everyone, let's talk about NFTs. You might have heard last year that Christie's auctioned the artwork for $69 million and recorded the transaction on the public blockchain, also known as non-fungible token or NFT. You also probably heard that the former Twitter CEO sold his tweet as an NFT for $2.9 million. So what is an NFT? Let's look at it step by step. Token is a custom digital asset which is recorded on a blockchain. It could be fungible or non-fungible. Fungible token could be a cryptocurrency, for example, and they are the same, so you can exchange one for another. Non-fungible, on the other hand, means unique, but they also can be traced or traded on the blockchain. In other words, an NFT is an asset with ownership recorded on a digital ledger, and that digital ledger is based on blockchain technology. And non-fungible implies that asset is unique, which might not always be true. Unlike physical world, digital asset can be duplicated or copied very easily, and NFTs attempt to prevent it by offering a proof of ownership. For example, in real world, it could be difficult to copy a painting. You should have the same materials, matching color paint, and obviously some artistic skills. In the digital world, it's easy to copy, it's easy to transfer, and it's easy to display. Let's say it's a picture. An NFT, they can increase the value of this digital asset by making it unique and by creating a digital certificate, which is recorded on the blockchain. But where NFTs fits in a legal framework, and what are the recent cases or development in a legal field with regard to NFTs? Before I answer this question, I want to say that the content in this video is for informational purposes only, and it's not legal advice. So, should NFTs be viewed as securities? And my answer is, it depends. As of right now, the SEC has not issued any guidance or comments related to NFTs. However, if you look at the law, and back in 1946, the Supreme Court case SEC versus Huawei issued an opinion which laid out the test for securities. And the test has the following 4 elements: investment of money in a common enterprise with reasonable expectation of profit to be derived from the effort of others. When you apply this test to NFTs, arguably an NFT could be viewed as a security. I think the main issue is reasonable expectation of profit. You might launch an NFT, but no one will buy it, so there will be no profit. So in that case, should the NFT be considered a good or service? If so, would UCC, Unified Commercial Code, apply? Let's take a look at the UCC Article 2. According to Article 2 of the UCC, goods means all things that are movable at the time of identification to the contract for sale other than money or investment securities and things in action. Are NFTs movable? Are they tangible? Can you touch an NFT and move it from one place to another? However, if NFTs should be considered as goods, I'm wondering, how would the consumer protection law apply to them? The main issue is that NFT transactions are irreversible. As far as I know, only the current owner of the NFT can transfer it further. In that case, we still do not have the answer about the right legal framework that should apply to NFTs. However, we already have some cases where intellectual property law applies. As you know, very often NFTs are a form of digital art, such as images, videos, pictures, or sound. Therefore, both copyright and trademark law would apply. Let's start with copyright. Let's say your NFT has an image or a sound of a brand. Let's say it's a picture of you with a bottle of a famous drink, like with a brand. Let's say it's Coca-Cola. The question would be, are you trying to confuse an NFT buyer that NFT is sponsored or endorsed or affiliated with a brand? If the answer is it's not sponsored or affiliated with a brand, so then trademark claim potentially can be brought against you. And of course, there are some exceptions such as fair use and First Amendment. And if you want me to talk about it, let me know. We'll discuss it further. So far, I found a few cases in the NFT universe that address trademark. And I want to talk about one of them. It's a Playboy Enterprises International versus www playboyrabbitars.app. The opinion was issued recently, actually last year, by Judge Victor Marrero in the Southern District of New York. In that case, defendants were selling fake Playboy Rabbits NFTs on their website. And the name of the website was playboyrabbitars.app and playboyrabbits.com. And obviously, Playboy filed a lawsuit alleging trademark infringement under Lanham Act and a common law trademark. As you can see, both website domains are very similar and almost identical to the Playboy's actual website selling authentic Rabbitar NFTs. And that website is playboyrabbitars.com. According to the court order, Playboy owns the registered Playboy marks, and Playboy has demonstrated prior use of the common law Rabbitars marks in connection with NFTs. Therefore, the court ruled for Playboy, granting preliminary injunction. So the next issue is a copyright law. The main question about NFTs and copyright is whether acquiring ownership of NFT grant the new owner copyright of the underlying work? And the answer is usually no. And before you launch an NFT or mint an NFT, I would strongly suggest that you check whether someone has right to the image or sound. Launching and minting, selling NFTs could be viewed as derivative work or distribution of a copy, or just publicly displaying the work. And doing so without a proper license is a violation of copyright law. Therefore, if you mint an NFT with an image that someone has a copyright of that image, you might be liable for copyright infringement. A good example of alleged copyright infringement case in the NFT universe is Miramax versus Quentin Tarantino. The case is still pending in California District Court, and the only document that I found available so far is the complaint. And according to the complaint, Quentin Tarantino announced that he will be issuing 7 uncut Pulp Fiction scenes as NFTs, and also will sell artifacts collection of up to 10 iconic cuts from Tarantino films as NFTs. However, back in 1994, Quentin Tarantino entered into agreement with Miramax, according to which all copyrights, with some exceptions, were granted to Miramax. And obviously, Miramax alleged in the complaint trademark infringement, copyright infringement, and obviously breach of contract. The case, as I said, is still pending, so I hope we'll see the decision soon. And in that case, NFTs have been made or were made from a famous work. In that case, from the movie. But let's look at NFTs from a different perspective. Let's say you try to mint an NFT from a picture that you made, and your NFT became so popular. Everyone is buying this, and someone started making derivative work. Let's say they make a t-shirts with an image of your NFT, and they sell them online without your permission or a license. If your image was registered with the Copyright Office, you will have no issue filing the copyright infringement case against the infringer. And finally, I want to say a few words about smart contract provision protecting copyright. Mike Shinoda, musician, I hope I pronounced his last name right, musician from Linkin Park, sells NFTs with specific terms of sale, according to which NFT owner has no copyrights of the underlying work. And I guess alternatively, you can have a different provision saying that you grant a license, and of course, if you wish to do so. That's all what I have for today, and if you have any questions, let me know. I also want to discuss another topic, NFT and privacy, my favorite, as you know. And if you have any questions, please send me an email, or you know how to find me. So good luck.